Closing the business. In the previous video, we saw how a business might come to an end because of financial difficulty, but businesses do close for other reasons. The business owner may in fact choose to close their business. There are many legal steps that must be taken to close a business properly, including deregistering the business name, terminating the employment of workers, terminating the lease or selling the business premises, disposing of existing stock, repaying any outstanding debts, resolving any outstanding tax liabilities, and dissolving the business structure. So what the business owner does is essentially the reverse of the steps that we looked at in earlier topics in order to set up a business. When dissolving the business structure, the process will of course depend upon the particular type of business structure that's been adopted. If the person is a sole trader, then they simply need to stop trading. If the business structure was a partnership, then there are a number of steps involved in order to dissolve the partnership. The debts of the partnership have to be repaid, so if there's enough money in the profits of the partnership, that money will be used. If there isn't enough money, then the capital will be applied to repayment of the partnership's debts, and if that's still not enough, then as we've seen in earlier topics, the partners will have to make contributions from their own personal wealth in order to pay the partnership's debts. Assuming that there is enough money within the partnership to repay its debts, and there's still money left over, then that money will be applied to repay any loans that were made by the partners to the partnership. If there's still money left over, then the partner's initial investment in the partnership will be repaid, and if there is still money left over after that, then that money will be distributed amongst the partners according to the terms of the partnership agreement. If the business structure was a company, then again, the company may choose to put itself into liquidation. So this is a decision that's made by the shareholders collectively in a general meeting. So they gather together, and if there are enough votes in favor of the motion, then the company can place itself into liquidation. So a liquidator is still appointed, and the liquidation will proceed in the usual manner, except that this time there will usually be enough money to repay all of the company's debts, and if there's still money left over, then that will be distributed amongst the shareholders. Rather than shut the business down, the business owner may choose to sell the business to someone else. The process of selling the business will be very difficult or very simple depending on the particular type of business structure. If the business structure is a sole trader or a partnership, then it will be quite complex and difficult because each business asset, each contract, and each employee will have to be transferred from the business owner to the buyer of the business. However, if the business structure is a company, the seller can simply transfer ownership of their shares in the company to the buyer. Once they have sold the business, the former business person can perhaps retire to a tropical island to live happily ever after, which is of course much better than the alternative. Thank you.